Hey, it's hello, hello. Hello. Hey, it's 10 o'clock. If we go ahead and get started, that way we can keep everybody on schedule. Let you resume your summer activities. So while we're getting settled in, for one thing, Brian, do we have a sign-up sheet? In the back. Okay, in the back. So make sure you sign up. May not necessarily take those in order, but we will get everybody who wants to talk a chance to talk. We've got the room till 2 o'clock. I hope that's overkill. Going to ask that everybody just limit their remarks to 5 minutes. And hopefully we'll be out of here between 11 and 12, but I'll be here as long as y'all want to be here. Going to give you a little perspective of how and why we're here. In fact, we've actually got the attorney from one of the cases, the Nichols case, that made it to the state board, which I'm sure everybody in this room is familiar with, but for laymen, we call that the Supreme Court of Workers' Comp cases. And cases end up there when the law is not clear or when there's a succession of appeals, but usually when the law is not clear. And so that's how we got to this point, is we're trying to cover and close a loophole, because I think, if everyone's being honest with me, and I believe they are, that everybody in this room has one goal, and that is that no worker is left uninsured. And so we want to fix that. The problem to get, like everything else legislatively, is how do we get there? And so we're going to hear those ideas from y'all. And because I'm probably the less educated member in this room as far as Peos, insurance, and workers' comp contracts, I put together an ad hoc committee. And I came up with 5 or 6 industry players, and then a couple more came to me, and I would have kept adding as many as came to me, because I didn't want any group to be left out. So it was basically insurance companies, contractors, PEOs, labor unions, everybody who dealt with workers and workers' comp issues, because I wanted it to be exhaustive committee. Was hopeful that all those people come to a consensus. It's very rarely that happens in the legislative process when you get that many diverse groups. But so we're going to see. We're going to have some discussion. We do have a draft, and I'm going to say this, that don't get too hung up on, obviously address certain lines in the bill if you want to, but don't get too hung up on thinking that this is close to being the final. It is far from it. I've gotten 2 more drafts just since yesterday. And then there are some previous drafts that some of y'all like sections of. And that's where our expert, Sean Marie Story from Legislative Council, will come in. In fact, if you ask me any hard questions, I'm going to turn her mic on and let her answer. And because of the climate, the environment we're in, the vast majority of our members are online, and understand that, but we do have a pretty good attendance. And then can we see other total? Okay, most of those are reps. So, with that, sign up sheet. Yes, it's still going around. Okay, still going around. David Pratt and whoever your representative, I'm going to let y'all go first because it was your bill. And if you want to give us some kind of context and more background information than what I've already given, please do so. And anybody, and again, I've been very loose with this, anybody that I pointed to the ad hoc committee, I said you could have a designee. And I didn't care if both of y'all came and spoke. And if you had two designees, like I said, I'd want any and every bit of input we can get. So, because as most of you have been around here long enough, we in the legislature end up coming back subsequent years and fixing previous legislation. I hope not to do that on this. I want to be very thorough and hope that we can get this right at the first run. And that's one of the reasons I wanted to meet pre-session, so that we would have kind of a running head start at this. And I believe I've met and talked with at length with everybody on ad hoc in the last couple of weeks. I've had a phone glued to my ear the last few days. So with that, Mr. Walraven, you're up. And everybody introduce yourself, what group you're with, so everybody knows who we're with. Thank you.
Thank you, Mr. Chairman. I'm John Walraven. I'm here on behalf of NAPIO, the National Association of Professional Employment Organizations. We are grateful for the opportunity to get down here in the summer, like you said, and get to work ahead of time and have a chance to bring all these folks in the room and the folks that are online that are interested in making sure that an injured worker in Georgia is going to be taken care of. They're going to be compensated, and that we also, on the flip side, want to make sure as a state that we have a stable environment for our businesses and for our insurance underwriters to do business in. Some other states aren't as smooth as Georgia, and they have rocky experiences, and I know people in this state are well pleased to speak of the stability and the coverages that we do get for these injured workers. Thinking about this issue, oftentimes we come down here and we're looking to find a solution to a problem. And the more I've noodled on this issue, especially regard to the fact that we've only got one or two cases that are specific to this issue, is that what we're trying to do with 397 and with the sub is try to address a symptom. The fact that, was it your client, Mr. Nichols? No, yours. The fact that, he was left in the position that he was in.
Mr. Robles was the claimant. Nichols' son was the employer.
Yeah, okay, sorry, thank you. That shouldn't happen. I mean, the idea that he took a job with somebody and he went to work and somebody directed him to stand in a pool of concrete, which is filled with chemicals that can burn you. He got badly burned. Turned out his employer was doing a little shuck and jive with regard to workers' comp. He didn't cover his employees. And so what he did was he tried to point a finger at somebody like my client here, Mr. Davlin, and said, you're now on the hook. Your PEO is now on the hook. For who? For this burned up man. Well, I didn't know that he even existed. Well, that's your fault. You got to pay for that. So where does the man's employer go? Scot-free. Nothing happens to him. Meanwhile, the PEO is on the hook for over $500,000 for this guy's horrible injuries. So the direction and control of these employees is not the PEO. PEO didn't ask him to stand in that concrete. And we're here today trying to find a way to allow what Georgians, they have the right to basic contracts. A person can contract with another person in the state. A PEO can contract with its client. That contract is ignored when it gets into the area of workers' comp, because we have this unique system where we're not going to let an injured worker go without being made whole. We're not here to change that, but we are looking to codify the ability to make our contracts mean something. That's really all this is about. So the symptom is this injured worker. The problem, why is he injured? Fraud. His boss went and bought a piece of paper from a PEO. He told the PEO, I have 9 employees. They all work in an office. So he writes the policy for 9 employees that have a really paper pushing job. And then he goes to the job site and he hands it to the foreman. And he says, he's covered. Guess what? He's not. So I don't know what that is, but I think when you go to buy an insurance policy and you lie to the person who's going to write it for you, and you take that piece of paper and you represent that piece of paper as something that it's not, I learned that in contracts. It's called misrepresentation. So what we're here today to do is try to put a Band-Aid on Georgia law by just asking the General Assembly to codify that these contracts are valid. The language in the sub, in our opinion, would incentivize this fraud. That, to us, is sort of not why we came for relief in front of the General Assembly. And we would like to figure out a way to address the fraud. A subcontractor that utilizes the service of a PEO would have no incentive to report more than 1 employee when buying workers' comp. And under this approach, the general contractors have little or any incentive to regulate or monitor workers' compensation insurance coverage on their job sites. If a contractor willfully neglects to report employees or subcontractors or their wages, they are violating Georgia workers' compensation law and engaging in fraud. They will then have no incentive to hire properly insured subcontractors. When a GC hires a subcontractor with insufficient or no workers' compensation coverage, much like happened in this case, they're engaging in fraud. But it's the PEO that's having to come out of their pocket, $500,000 to take care of this guy. The general contractor hires and contracts with the offending subcontractor. The PEO does not. They supervise the job directly, or at least they're supposed to, not the PEO. They can at any time verify that all contractors on their job sites have workers' comp. The PEO cannot. And lastly, the GCs and the subcontractors are the ones making the money on the job, not the PEO. This would basically shift all that liability onto the PEO. So what we approached the General Assembly for was a way for the contracts to be honored. We understand that Georgia has a unique legal structure over at workers' comp. We want to make sure that we're not here to upset that apple cart. Lane Davlin is the state president for the PEOs here in Georgia. And he's been doing this for over 30 years. And in over 30 years, when selling PEO client services, he's seen enough. And I'm going to ask him to join me and offer some real world examples of how this happens when the rubber meets the road. Thank you.
John, thank you. Good morning. Good morning, everyone. My name is Lane Davlin. I've been in the PEO industry since forever, 32 years. I'm with Co-Advantage, and I'm the Georgia chair for NAPIO. We have had issues throughout the U.S., especially in Florida, with fraud. Mainly, it's the professional employer contracts with a client. The client pays those employees through the professional employer. We cover those with our workers' comp. If they don't report those employees to us, we have no knowledge of them. We don't even know they're on the job site. It's just like reporting a new hire to the feds. It's required. And when you hire a new employee, you should be obtaining new hire forms, tax forms, and everything else. You can use a portal. You can use the good old-fashioned forms. You can even call in the data. So it's very easy to report information to a professional employer. Once they report that, the professional employer has that employee under their comp and is aware of them and covers them. Professional employers have no knowledge of subs that come in, and we require that the construction groups actually obtain certificates of insurance for their subs. And it's very clear that we only cover the employees that we're paying. If we're not paying them, we have no knowledge of it. So that's really where the majority of the issues hit is employees that aren't ever reported, that are paid under the table mainly. So, there isn't anybody that's actually collecting the fair share. The feds, the state, the work comp carrier, no one. Anything else you want me to? Yeah.
Thank you. And instead of, because I, again, don't want to draw, I want to hear from the ad hoc members because those are the experts. So if any of our members, and I think Brian said we've got close to 100% from our committee, so most of them are online. If we could hold off on questions, or if you want to, in the chat box, let Brian know who you've got a question for. We'll come back to that. But we're going to go straight down to the speakers, and then we'll do a round if folks have questions. And the reason I want to do that is hopefully between hearing from every expert in the state, we'll hopefully answer some of those questions from the committee members. That's okay. Mike Dunham with the AGCGA.
Good morning. Members of the committee, my name is Mike Dunham. I'm the CEO for the Associated General Contractors of Georgia. And I just want to give some practical industry context to this discussion. When the owner contracts with a general contractor, he then in turn contracts with a lot of subcontractors. Those subcontractors come and go throughout the life of that project, and the general contractor secures a certificate of insurance from each one of those subcontractors. And he relies upon that certificate of insurance to cover all the employees of that subcontractor that works on the job. The situation we have here, as it was just described, is that during the life of the project, this general contractor has a subcontractor that provides insurance, but it's through a PEO insurance company. He's assuming the insurance company, the PEO, is covering all the employees brought to that site. For an example, if that day they contract with 50 folks, that's the block, but that's not the subcontracting industry today. Their workforce comes and goes each week as they pick up the help they need or find new employees, and they go right to the job site and they go to work. If they call the union hall and say, I need 5 folks, we're behind schedule, send me 5. Those people hit the job site for that company, that subcontractor, and he has a certificate of insurance. That general contractor is relying upon that insurance certificate to cover those employees that are there that day. And so our concern is that if the process as they described is in case, we won't know that they're not covered. And that leaves the general contractor upstream at risk. So clarity of that, insurance covers the employer, employees en masse total. Either that or contractors would have to look to see that insurance from a PEO could be suspect because we wouldn't know that they were not covered. It's pretty clear. Any questions?
Stacey Freeman.
Hey, good morning, Mr. Chairman, members of the committee. My name is Stacey Freeman. I represent the American Property Casualty Insurers Association of America. That's a national trade association, approximately 1,000 insurer members, and they write approximately 80% of the Georgia market. APCIA appreciates your efforts, Mr. Chairman, and those of the committee. We do think this is an issue that needs to be addressed and support the efforts to close the gap. I would just say quickly, APCIA has two suggestions. One, that the law state that the PEO contract state that all employees of the client must be covered by either the PEO or the client's policy. So that would address some of the issues of fraud and lack of coverage. And second, to potentially require the PEOs to provide the state board with the names of their clients. That would help with transparency. As was mentioned earlier, if you know that somebody's covered by a PEO, then that would put you on notice that potentially you want to look further into that coverage and if there are any limitations there. Thank you. Are there any questions? Appreciate it, Mr. Chairman.
Stephen Berry.
Thank you. I'm Stephen Berry. I'm General Counsel of Builders Insurance Group. We're a mutual owned by Georgia Home Builders, and we're the largest insurance company based in Georgia. So as such, I have the interest of the insurance industry and the home builders industry at heart. And I just want to echo the comments of Mr. Dunham and Mr. Freeman. The only bill that I've seen proposed doesn't address this problem at all. It seems to be just an attempt to expand the immunity that PEOs get without covering those uncovered workers that we worry about. And so, and another point I'd just like to make to address the complaint that, you know, the PEOs don't put that worker into the concrete. Well, they don't. But the PEOs put that uninsured subcontractor on the job site. That's an inevitable aspect of the PEO business model, is to let people pretend they have insurance when they don't. And so that's what I think the legislation needs to address. Thank you.
Thank you. Ralph Perales.
Thank you, Mr. Chairman, members of the committee. I'm Ralph Perales. I've been before you before. I'm the president of GWA, the Georgia Injured Worker Advocates. We represent injured workers in workers' compensation claims. Let me start out by saying that I don't think anybody, certainly not us, is against PEO. I find PEOs to provide a very useful model of business. It's a good business model. The problem is that through this Nicholson contracting case, we have exposed a tremendous gap in coverage, a loophole in the workers' compensation laws. And this was a case of first impression before the State Board of Workers' Compensation. And the State Board, after looking at the case, decided, appellate division decided that a PEO has to cover all employees, not just cherry pick which ones are going to be part of this contract in the event that one of those workers that were not initially placed under the PEO gets injured, as it happened in the Nicholson case. And so the problem is that without a certificate of insurance, Nicholson contracting was out of business. It just could not get jobs. And so what it needed was that piece of paper. And we don't want to get today into who committed the fraud. My understanding is that the PEO company approached Nicholson to do this deal, but obviously don't have the details of who suggested what they do or how they do it, whether there was, you know, bad intentions, fraud in their minds, whatever. We're going to put that aside. The fact of the matter is that this company decided to sort of put 9 out of 25 employees into the PEO contract, the service contract, and then put the other 15 out in the field, the ones that are actually doing the work are subject to injury mostly, basically with no insurance, because now he had that certificate that he got from the PEO that he could show the contractors and everybody and say, I have insurance, I'm okay. And so obviously if nobody gets injured, you know, nobody finds out, nobody gets harmed, so to speak. except the insurance company and the PEOs, because they are underwriting more risk that they're collecting premiums for. And so we need to close this gap. Anytime you have a gap in coverage or a loophole in workers' comp, it's an anathema of workers' comp system. It goes against everything that the workers' system was set up to do, the reason for having workers' comp. So we got to close those gaps. Now, I'm sympathetic to the comments made by the PEO folks today, because they ended up with a $500,000 bill that they were not expecting. They didn't collect premiums, they didn't collect money for that risk. But the reality is that in workers' compensation, there are only 3 places where you can put the cost of an injury. And the cost of an injury goes beyond medical costs. There's societal costs. You know, people have to go into maybe Medicaid afterwards, or food programs, SNAP program. So there's a tremendous cost. Now, as far as workers' comp, you obviously have the cost of the benefits provided under the Act, and that cost has to fall somewhere. Now, nobody wants to say, I'll take it, but we only got 3 places where we can put it. The injured worker, who's gonna be uninsured, the taxpayers, who are gonna have to bear that cost, or related to the taxpayer, that hospital that ended up with a $200,000 plus bill in the Nicholson case. Now, imagine if that hospital is back home. You know, we already have hospitals under tremendous pressure in rural Georgia. If they get stuck with a $200,000 bill that they cannot collect, I mean, that's a big hit for them. So, and then the other place that we can put it is the employer insurers. Under the code section, under the Workers' Compensation Act, we treat them as one, you know, the employers and insurers. So that's one of the 3 places. There's no other place to put that cost. So the legislature has made already that decision, a policy decision, where we're going to put that cost, and that's in the employer insurers. Now, the PEOs are, of course, you know, doing business in this area. You know, I hope that they're profiting in this area. So they should bear some of that risk. The risk is really all, I mean, I know people start thinking, oh my God, I'm going to end up paying all these bills, but there are many things that a PEO can do to prevent this situation from arising. Very simple things that don't cost a penny. Number 1, they can do what my landlord requires me to do with my liability policy in my office. I have to name them as a named insured. Because if my policy gets canceled, my landlord gets a notice, and they're going to be calling Ralph Perales and asking what's going on. You got to show me your insurance because I see that it got canceled. Doesn't cost a penny. So a PEO, if they want to enter into contracts with companies where they just want to absorb only a portion of the employees, and we have a law that says you're going to be responsible for all of them, so you better pay attention. There's certain things they can do. They can name themselves as named insured in the policy, require that certificate of insurance. It's a short phone call to call that insurance company and say, is this good? Because there's a lot of fraudulent certificates of insurance floating around out there, you know, particularly in the trade, in some of the trades. So very simple. The other thing you can do, the state board already has a way to track this. You can go sign up at the state board to be notified when a workers' comp insurance, the comp insurance of an employer changes. There's a change. You get an email notification saying, got canceled, got changed, whatever the situation. It's free. So a PEO in this situation, like the PEO in Nicholson, could have very easily signed up so that he would have been alerted or there's no coverage here. Or pick up the phone and find out, because in that certificate of insurance, there was a little fine print that says we only covered those employees that are part of the service contract with a PEO. Granted, most people are going to look at it and think, well, that means all of them, but now we know that that's not what it means. But there's a couple of things that they can do. The second thing is, you know, the way to approach this problem is already in the law. We already have a model to deal with this, and that is what Mr. Dunnan was referring earlier about, you know, which is Code Section 3498, which makes contractors responsible for an injury if the sub doesn't have it. That's why contractors are very, very careful about collecting certificate of insurance to make sure that the subs, you know, have coverage, because otherwise they're going to end up paying for that claim, much like a PEO had to do in this case. Now, one other thing too is that the contractors' premiums are going to go up at the end of the year when they get audited, because the insurance company is going to come calling and say, all these folks you pay, either 1099 or companies where they insure, show me the certificate of insurance. Otherwise, that money goes into their payroll and the premiums go up. So they have an incentive to do that. That's a business model that has been working in Georgia for years. It protects the injured worker in the event that something happens and the first tier employer, the subcontractor, doesn't have coverage, or the coverage was canceled, or something goes wrong with that policy. It can go up to the contractor. And under the law, the contractor has the ability to go back and collect from the sub. Now, granted, in this situation, Nicholson more than likely was judgment proof. The PEO has the ability to go back to Nicholson under that contract that they signed and say, you got to pay us back that $500,000. Now, they may not collect it. They may collect part of it. But what we're doing is we're putting that risk, that cost where it belongs, because the alternative is to leave it on the injured worker who gets no medical care. The hospital doesn't get paid. He doesn't get benefits. He goes into the Medicaid system. He goes into food stamps. He goes into all his social welfare programs. So we should not place the burden there. Now, if somebody can come up with a fourth place where we can put that cost that helps everybody, we don't have a problem, as long as don't put it on the injured worker. So also under the law, I want to address one comment that was made. We do have the freedom to contract, but we don't always have the freedom to contract away legal rights sometimes. And under the law, under the Compensation Act, under 34.910, the code section, it says that you cannot contract out of workers' comp, basically. You cannot enter into a contract to sort of absolve yourself from workers' comp. So, PEOs need to be careful. I mean, like I said, I like to see them thrive. They provide a good service. They provide a scale of economy of scale for small companies to have access to more reasonably priced products. But at the same time, they're going to have to bear the risk. Now, you as the legislature can come up with a bill like they're trying to do in Florida. A lot of bad actors in the PE industry coming out of Florida. Not to say that everybody's bad. There's bad in every profession, every industry. But you can come up with a lot of regulations, to sort of regulate PEO and the practice that they're not going to like, and we don't like regulations. We like to keep regulations to a minimum possible. So here you can regulate that in order to take care of the problem, or you can simply say, PEOs, you're going to police your own industry. And the best we can do that is by putting that burden on you to ensure that if you go into a contract with somebody that is going to sort of pick and check, cherry pick employees and put them here, you better make sure that the rest are covered. Otherwise, you will be responsible for those employees. So that is sort of the model of the bill. What you need to ask yourself is, will the proposed bill would have addressed the Nicholson problem? Would that injured worker have been covered under this proposed legislation? If the answer is no, as it is on the latest drafts that I've seen, that does not cover would not have covered Mr. Robles in that Nicholson case, then that's the wrong legislation. So if you have any questions, I'd be more than happy. Today here with me, I think speaking is Ken Thaxton. He's a GWA member too, but he was the lawyer that had the Nicholson case. I commend him because not many lawyers would have taken on that case. And that sort of opened up, he can tell you more about it, but he's got a lot of more cases against PEOs, and he's finding a lot of what some of these bad actors are doing. And unfortunately, when we seek to regulate that bad conduct, we got to regulate everybody. We just can't pick and choose. So unless you have any questions, Mr. Chairman, I'll turn it over to Mr. Thaxton.
We're going to come back for questions. We'll bring up Mr. Ken Thaxton.
Good morning, Mr. Chairman. Thank you for the meeting today, and thank you for the speed with which the legislature is trying to address this. I agree wholeheartedly with the comments made by Mr. Perales and the two gentlemen before him. I'm not going to try to tell you guys what to do from a policy perspective. We'll just tell you I've got a number of these cases. I represented, as you know, Mr. Robles in the Nicholson contracting case. And like Mr. Perales says, there's good actors and there's bad actors. Me and my dad own three family businesses. Unfortunately, the last recession was very hard on those businesses. That's why I went to law school. So I've been an employer. I don't have a problem with employers. I've been on that side of it. I've seen workers' comp accidents and the lengths that we went through to avoid people getting hurt on the job. So nobody wants to see an injured worker. But I'm just going to focus sort of on the bad actors because unfortunately, you know, bad actors is often why you need legislation. You know, you don't necessarily need a rule for the good person. But what we've seen from some of the bad actors is that they have decided, because I guess they don't feel like there's going to be any sort of enforcement on what these decisions, they have decided that if you are a PEO, if you're a PEO employee or you're the employee of the company using the PEO and you're not hired by the PEO, leased by the PEO, and paid on the date of the injury, like if you had been paid the day before the date of the injury, but you didn't get paid on the date of injury. Now, keep in mind, hourly employees, their payrolls usually run in arrears because you got to report how many hours they work. So now you've put control at multiple levels from the supervisor who doesn't want an injury on the job up to the HR department, all the way up to the PEO. You've put control into whether that payroll gets reported or not in the hands of all these different people. The PEOs, some of them are taking the position, if you weren't paid on the date of the accident, that's the end of the story. Case is controverted. You weren't paid on the date of the injury, case is controverted. And this case is it'll be at the Supreme Court of Georgia. They ain't picking it up. It's not happening. So that's one of the things we're seeing. The other thing we're seeing is that, you know, the certificates of insurance on their face say we're only covering leased employees. We're not covering subcontractors. Well, obviously that's unlawful under 3498. You cannot exclude a subcontractor on a certificate of insurance. So then that creates this issue of, well, somebody who gets the certificate, say a general contractor, as I think it was Mr. Dunham who was talking about earlier, has that person unreasonably relied on this certificate because on its face it has language that's contrary to law? So what if you reasonably rely or unreasonably rely? I was just in a hearing where there was an expert on the stand for an hour talking about that. Very complicated. And so, you know, at the end of the day, we're not trying to hurt PEOs at all, because guess what? PEOs want tort immunity. So what if Mr. Robles in the Robles v. Nicholson case, what if Mr. Robles was trying to sue his employer who was ultimately responsible for him getting in that concrete, that wet concrete, in tort for negligent something, negligent supervision, negligent instruction, whatever the case may be? Let's say that Mr. Robles is trying to sue him in tort, but his boss is a PEO employee. The PEO is going to come in and say, no, under 34911C, we get tort immunity, right? Because the PEOs want tort immunity, but it's the quid pro quo. If you're going to get quid, you got to get pro. If you're going to be saddled with workers' comp liability, you get tort immunity. And if you get tort immunity, which the PEOs want, you got to have responsibility for the workers' compensation benefits. So we're actually trying to help the PEOs by making it clear that, yes, they will get tort immunity, but if nobody's stepping up to pay for an injured worker's workers' comp benefits, then the PEO who had sent a certificate of insurance somewhere and the injured worker was on the job site because of that, they're going to get covered by the PEO. So that's sort of what we've been seeing. Any questions from me?
Okay, we may have some questions for you later. Perry Sartain.
Thank you, Mr. Chairman and committee members. Perry Sartain, I'm out of Gainesville, member of GWA, and I've represented both employers and insurers since 1985. Also a member of the ad hoc committee. I would like to just second the information and the speech that Mr. Perales gave. As I see the case, what we had is one employer, a PEO, then carves it up. And that's what created the confusion in this. They wanted to cover the administrative folks, but not the people in the field. That creates the confusion. And Mr. Perales is correct. There's got to be some responsibility, and there's got to be some responsibility for the PEO to ensure that everybody's covered. It's just improper to have employees out there uninsured when there really is easy methods to make sure that they are covered. Look forward to being on the ad hoc committee, working this out and presenting something that'll accomplish that. Thank you.
Thank you, Perry. Robert Bourne.
Good morning, Mr. Chairman and members of the committee. Thank you for appointing me to the ad hoc committee. I'm an attorney. I practice workers' comp law in Forsyth County. I represent injured workers. I'm here today on behalf of Georgia Trial Lawyers Workers' Comp Section, otherwise known as the WCCL. If I understand the PEO's concern is that they're victims of fraud. So, I mean, I'm sympathetic to that issue, but it's their clients and they have ways of verifying whether their clients are being truthful with them. As Mr. Perales pointed out, the board already has a way to verify they have insurance and to track that insurance in the event of a change so that they can come back to their client and say, hey, we got notice. You don't have comp insurance. You know, we're subject to comp under statutory employer rule, and you guys need to take care of this. So the burden has to ultimately fall on somebody, and the statutory employer model seems to be the best way. If there's another way, that's good too, but you just can't be in a situation where the employee ultimately bears the burden. So I think that Judge Vinson's decision was well reasoned, and it was a good result. Final thing I wanted to say is we all understand statutory employer rule and the flip side, which is tort immunity. Okay, the general contractors responsible for unlimited comp from all the subcontractors, but in exchange for that, they have unlimited tort immunity. The PEOs, I think they need to understand here is what they're asking for, in effect, is they want the unlimited tort immunity, but on the flip side of the coin, they want to limit their comp exposure. But that's kind of having your cake and eat it too, and that's not how it works, or I should say not how it should work. So hopefully we'll be able to find some way to fix this loophole so that the bad actors don't take advantage of the system. It's a good start, you know, to draft this legislation. I'm with Ralph on that. I don't think this does a job, but I think if we come together, we can come up with something. Hopefully it satisfies the PEOs. I mean, I understand now. I don't want to be a victim of fraud either. It's unfair. So hopefully we'll be able to come up with some kind of resolution. Thank you.
Thank you, Robert. John Barber and Mike Iverson.
Good morning, Mr. Chairman, members of the committee. I'm John Barber with the Independent Insurance Agents of Georgia. First of all, I want to thank the chairman for his 3 stated goals that he's put out for any legislation that moves forward. Those are closing the loophole that will leave workers uninsured. And it sounds like today that that goal is shared by all involved, and it's certainly one of our top priorities. The second is to create clarity legislatively so these cases don't have to be litigated. And I think that's important, particularly for the injured worker. If you're injured, you don't need to litigate to the point where in order to decide are you going to get coverage or not. So that is absolutely a fantastic goal. Thank you, Mr. Chairman. And then third, be consistent with the State Board of Work Comp decision. And the Nicholson case has been referenced a number of times today. I want to reference one section of the opinion. We've talked about the statutory employer section and the importance and how that relates to the coverage and the PEO's unique position. The Nicholson case says the only purposes in the Workers' Compensation Act for considering a person or entity a statutory employer is to extend that person or entity the protection of the Act's exclusive remedy provision and to impose potential liability for workers' compensation benefits to employees who without the statutory employment designation would not be considered employees of such person or entity. And so it's that last section there, that who would not be considered employees of such person or entity. And we did hear testimony from the PEOs to start off the morning that they only want to cover those employees that they know of. But we've also heard testimony from others that that's simply not how the workers' compensation system is designed. The system is designed that no one is left out, and we cannot contractually obligate those liabilities away. So I want to call up one of my executive committee members, my president-elect of our association, Mike Iverson. He is a practicing agent here in Georgia and somewhat of an expert in this area. So I'll turn it over to Mr. Iverson.
Morning, everyone. Mr. Prowlis did a really wonderful job, and I guess I just want to summarize and maybe keep things really simple, right? Because sometimes we make this so complex, and it can be because so many laws are involved. But the goal in the Nicholson case was all about really an orphaned employee, somebody that nobody wanted to pay for. This poor guy went to the job site to give a hard day's labor and ended up with a life-changing injury that everybody ran from at claim payment time. Thankfully, the work comp board stepped in and said, this isn't right. The employee has to be taken care of. They exposed the loophole that exists in the law, and then they gave a ruling. It's a tough ruling. I mean, if I'm the PEO, it's a tough ruling. I see these tough rulings happen to insurance companies all the time. But first, we have to start with the workers' compensation system and really say, okay, how is it designed and why is it designed this way? The concept that workers' compensation is there's duplication of coverage all throughout the system. Meaning if I'm a general contractor and I hire a sub who hires a sub, I'm responsible for everybody. The way I mitigate that risk is I get certificates of insurance from their insurance company showing that that company has coverage. And on that certificate, it gives me a work comp policy number, it gives me expiration dates, it gives me all that information. In the case of PEOs, a work comp certificate is generated to that contractor in the name of the client that shows a policy number that is not a true workers' compensation policy for the contracted company. Hence, we end up with this nasty gap. And the goal of the system is that the people are closest to the transaction. When the board's looking at cases, they're looking at the people who are closest to the transaction and they're saying, okay, this one failed, right? So our system is built with duplication and backstops. So when this employer fails, the next one gets pulled in to pay for the claim. And when a PEO enters a co-employment, now it's a co-employment. This is a partnership between the PEO and the employer to protect employees. There are things they can do to mitigate the risk. They can say, hey, you got to have a work comp policy or we don't do business with you as a PEO. They can audit every one of our carriers, every insurance company who does business in Georgia, builders and all the others. What do they know? They know that sometimes people don't know what their payrolls are going to be. Sometimes they don't know how many people they're going to have. Sometimes they may pick somebody up. So they reserve the right to do what at the end of the year? To go out and audit and make sure that that information is correct. So when you have practices and procedures that can be done and perhaps aren't being done to mitigate the risk and keep it at the employer level, I think we're in great peril to not do something about this law issue that's rising in frequency in Georgia. that if we don't do something to make it concrete, to keep any employees from being orphaned when all they did was report to work to do the best they could and they got hurt. I don't see how their employer's fraud, if it was fraud, should have an impact on their ability to have their hospitalizations paid for, their loss of limbs, whatever may have occurred. So I guess that's my way of really kind of taking this very complex issue and just simplifying it. And we have the case. We have the case that proves the weakness in the law. So now the question for this group is, what do you really want to do about it? And I feel confident that this issue is in good hands. So thank you for what you do.
Thank you. That is everybody who was signed up to speak. But if there's anyone who would like to speak, let me know. I want to make a couple of comments. First of all, it was unfortunate in my choosing of this date and time. The State Workers' Comp Board is meeting as we speak. So hearing cases, had that unfortunate timing not existed, they would have been here. And so I spoke at length with Judge Vinson, and he would have liked to have been here. This issue did make me, several people have mentioned the State Workers' Comp Board website. You could check certificates and about the notification, but I still think there lacks, like you can see if they're covered, but the details of who's covered and who's not, you're not going to get a notification if there's an uncovered worker. And if anybody else has got questions for specific people, Mr. Thaxton, if you will retake the podium, I've got a question for you. Because we keep, I know we seem to be piling on the PEOs, and in the Nicholson case, I'm assuming, and I guess that's what I'm going to ask you, is that through hours and hours of investigation and research, the PEO was found at fault. But am I right to assume that in another like case, that the subcontractor, like if I go to a PEO and I'm the one who has lied to get that piece of paper, and I say, hey, I got 4 office workers, and then I put someone in the field that is in a dangerous work environment, the PEO has no knowledge of that. And so I guess what I'm asking you, in that case, was there enough, could the facts have been different, or the results have been different? Is that why the PEO was found at fault? There was enough evidence that the fraud was held on behalf of the PEO and not the subcontractor?
I don't believe in any of the cases I've had so far that there's been really any evidence that the PEO ever asked. They don't think it. This is not. This is just my opinion from thousands of hours of dealing with this on about 8 different cases. I don't think that the PEOs that I'm dealing with care whether or not they know who everybody is. They simply don't care because they've decided that. And I've taken a lot of depositions of their executives, and they've decided that we can send certificates of insurance all over Georgia on behalf of many different downstream users of our PEO services and insurance, right? We do not have to provide coverage unless on the date, minute, hour of injury, that person was hired, leased, and paid by the PEO. So they don't care. They just don't care whether or not. I don't even know that they're asking. I'm not saying that they never ask, but they don't think that it's their job to make sure that the entity that they're doing business with is either telling them about all of the employees or making sure that those employees that they're not telling them about are covered, because they've decided they're personally not on the hook, and they know it's going to be very few claimants attorneys who will take those cases, and it's going to be years of litigation for any claimants attorney who does take it. That's just my experience.
Okay. Thank you. Anybody from the PO delegation like to respond?
Sure. Yeah. I mean, we all care. I mean, we want to know about all the employees, because if we don't know about them, we can't collect any money. So we want to know about them all. We want them all on our pay. And they're covered the minute that they're reported to us, not when they're paid. They actually don't have to receive a check yet, but they have to be covered under a pay period so that we know that they're on the job, that they're even live. So yeah, we do care. We want everybody on our pay. So.
Okay.
Add one thing, Mr. Chairman. We have to also be sure to make sure that we are talking about the same thing here. Employees are the employees that get a W-2. I'm talking about employees. Every time you get a new employee or you lose an employee, that information always is reported to the PEO in order so that they can get paid and they can get their benefits. We're not talking about employees over here when we're talking about subcontractors. We're talking about day laborers. Sometimes we're talking about people that are never reported. They don't, and the idea that a PEO can somehow have eyes and ears on every job site in Georgia to be able to figure out who brought who to work today. We've heard great testimony today about how fluid these job sites are with regard to who comes on and who goes off. It sounds like a revolving door to me. I don't work on job sites, but we're not talking about an injured employee. We're talking about an injured laborer that is an employee of a subcontractor who the PEO doesn't even know is coming to the job. So I think it's a little bit difficult to expect the industry to be policing subcontractors.
That's fair. In the Nicholson case, do we know if the gentleman was a W-2 employee or for lack of a better phrase, picked up at Quick Trip that morning? Sure.
Chairman, the injured worker in question, he was, if I'm not mistaken, a W-2 employee of Nicholson Contracting. Nicholson Contracting had entered into a PEO services agreement or similar document with the PEO in question, but Mr. Nicholson had not reported the injured worker's payroll to the PEO. So Mr. Robles, the injured worker, was a W-2 employee, I believe, of Nicholson Contracting, and the PEO with whom Nicholson Contracting had entered into an employment agreement had sent a certificate of insurance to the ultimate client of the contracting services that were being done. It was a center over in East Atlanta. And so the reason that Mr. Nicholson was on that job site was because the PEO had sent a certificate of insurance purporting to cover employees of this contractor. But Mr. Nicholson was paying Mr. Robles from Nicholson Contracting.
Right. So if he was a W-2 employee, why was some of the negligence not given to Nicholson Contracting? Because it seems like there's may have been fraud on two parties. Because if he obviously already had a W-2 employee, he was working the week before and probably the month before. And so I guess it's hard to determine, and that's what I'm wondering during all the investigation, like who is more fraudulent? Like, did Nicholson say, hey, I don't care how you do it, I just want the cheapest rate, and I want two things. I want a piece of paper, and I want the lowest possible rate you can give me. And I'm going to close my eyes and ears, and however you do that. Or does he go to him and say, hey, I know how this works. Can you cover my office workers? I can afford that. I can't afford everybody else. And obviously we're not privy to all those conversations, and that's left to investigators. But it seems like most of the cases or the circumstances we're talking about today has put all of that on the PEO because that's how the State Workers' Comp Board ruled. But as thorough as they are, I'm assuming they ruled based on investigations. But since he was a W-2, I think it begs the question, was Nicholson compliant in any way in this case?
Can I step back and sort of address it from a slightly bigger perspective, which I think might answer your question? If the PEO can sell a product, an insurance product, whereby the employer gets to pick and choose which of its employees it wants to place on the PEO payroll, it can just do that, and the PEO has no responsibility to do anything else. Okay. Then now you could have various levels of fraud or negligent misrepresentation or misrepresentation at any number of different levels in the process, from the PEO's office to the leasing employer to then I've seen the leasing employers or the clients who are using the PEO then go out and hire other people who are going out and getting people out of Home Depot parking lots, right? Because if that product is allowable under Georgia law, the product being insurance via PEO, whereby the employer can pick and choose which employees it wants for insurance, then now the PEO can sell a product, right, that looks like workers' comp to general contractors and intermediate contractors and landowners, right? But it is in fact not workers' comp because it is insurance on an employee by employee by employee basis, instead of following how the Workers' Comp Act is set up, that an employer is subject to the act. See, what Mr. Nicholson did is, with the help of the PEO, I don't know that either one of them were fraudulent, but with the help of the PEO, what Mr. Nicholson was able to do by use of the PEO contract is something he could not have done otherwise. He was able to pick and choose which employees, for whatever reason that day, he wanted to cover for workers' compensation insurance.
Well, if that's true, then so why wasn't Nicholson contracting held partly liable or complicit in the act?
Well, I believe the ruling was that the insurance company could pursue action against
Nicholson.
Against
I
Nicholson.
wondered that myself. Okay.
Yeah, I believe that was the ruling, if I'm not mistaken, that they could. It was basically between them. You guys are
right.
You guys are in.
We're going to find you, and if you think they're complicit, then you go after them.
Right.
Okay.
Or in the initial underwriting process, you can make sure that there's a certificate of insurance for those employees who you're not putting on your payroll, or after there's a claim reported at the end of the year, just like general contractors and intermediate contractors under 3498, whose insurance companies all know how to audit in these types of situations, because you better believe that framing companies working for an intermediate contractor that might be working for some, big construction company with a flag flying on top of a crane and their name out there in Midtown, right? You better know that there's some people getting picked up, by framers and stuff at Home Depot parking lots. Well, those insurance companies for those big C-SIPs, no-SIPs, those big construction projects, they know how to go and audit for those gaps, right? And so I think that we're saying the PEO, they can do that. They can use that model of auditing to audit after the fact for, okay, there was unreported payroll for some of these employees, and we ended up covering the compensable injury for some of this unreported payroll. We need to go back and audit for that, get the premiums that we would have gotten, and then they would be in the position that they would have been in, just like statutory employers, like contractors.
Okay, that's fair. All right, Mr. Holly, who do you have a question for?
Actually, for Mr. Thaxton, if you don't mind. And if that's okay, Mr. Chairman, also one for Robert Perales. Let me start, if you don't mind. Thank you for taking the time to come down here. Whether through the Nicholson case or even in your own experience with these matters, what has been the biggest resistance towards PEOs actually doing their audit, since a lot of this is, it would be in their best, I would think it would be in their best position to be able to see in terms of exactly which employees would be covered and which ones aren't, since subcontractors can be picked up all the time. it just worked for the sake of liability. Is there anything that is stopping industry-wide for them to be able to actually perform an audit of their employees to see who's covered and who's not?
I can't speak to industry-wide, what would be the holdup. And I'm not intimately familiar with audit processes among like the Zurichs of the world who do a lot of big construction projects. But I know that their auditors know how to audit very complex situations when you got multiple levels. As far as I don't think I know the answer to your specific question. I'm not sure if maybe a part of your question is why isn't the PEO accepting the case too? Kind of.
Yeah. So I guess, you know what, and I thank you for attempting to answer that. Maybe that is something that's more available to any, I guess, the members of the ad hoc committee, if you might be able to, PEOs particularly. But thank you.
Okay.
And Mr. Chairman, if that's okay, if I could ask for, I guess, for Mike Dunham or for any of them, if you might be able to speak, Mr. Berry, that's fine.
Okay, with the professional employer, we don't allow the clients to pick and choose. They have to put everybody under the federal ID that's a W-2 employee on our pay. If they choose not to do that, we don't know about it. We do try to underwrite on the front end. We have risk personnel that go out and site visit periodically at the beginning, make phone calls. So we do try, but we can't be on every single job every single day. A lot of PEOs don't write GCs anymore because of these exposures, because we can't know about them. As far as the audits, it's done as a pay as you go. So the payroll that's being run, we're charging for that particular amount of exposure. If they got 20 employees, they're being charged for 20. If they got 10, they're being charged for 10. Of course, there's other options like a minimum premium policy to cover those gaps, to cover those uninsureds and other things like that they do go through an audit. Some professional employers offer those to their construction clients and do an audit every six months. So there are things in place. We use Zurich, we use all the big names, and yes, they're in the offices. They do sporadic site client visits as well, but it's got to be an abnormal reporting over what they see, compared to the norm. So,
thank you.
Your question's a great one, and it really gets to the crux of it. And the answer is they haven't needed to. The law has already offered protection. So why would you spend money on something you're not required to do? And you're afforded protections with.
And that I figured that again, and let me just say this first. I think that I would like to think in an idealistic way, at least, that that everyone is trying to enter this in a good way.
Yeah.
And trying to do about, literally are trying to go about the right way to employ. But if even through common practice of industry, if it's so widespread and there's really not a lot of regulation to that extent, then, we're seeing, I guess maybe we're all seeing that literally trying to make sure that certificate of insurance is actually applicable. It's because there's really no safeguards really there, then it's bare minimum can be something that can be easily accepted on a job site.
Yeah, and I'll take that a step further and just say, so let's carve out all of the rest of the industry. So what's the common practice there, right? Audits are nice. Audits, all they do is make sure that the insurance company gets the premium for the exposure. That's all the audit is. The audit doesn't mandate coverage. It doesn't say who's going to be covered or anything else. And so every other employer in Georgia outside of a PEO who carries workers' compensation, they may have day laborers that they pay for cash and the auditor doesn't catch. Guess what? That injured employee is taken care of by the work comp system. And so the issue all comes back to that little piece that the Nicholson case has exposed and made extremely public and then evoked a reaction because what could come, I mean, if we're going to make the field level for everybody and say, hey, if the PEO is providing workers' compensation, then it should respond like workers' compensation would, which is for all those cases. And so if we do that, I'm certain that the industry is going to have to get better at audit, going to have to be a little better at underwriting who their business partner is going to be. And that's what the insurance industry has done for years. They still get taken advantage of. I feel for fraud. But at the cost of fraud, we don't want to exclude legitimate injuries, right?
Right.
So how do we bring that down while still covering injured employees? And I really think that this group really needs to look at the fact that the rest of the industry operates this way. And we're talking about one small carve out for employee leasing.
Thanks for explaining that.
I'm gonna go ahead and ask, anybody online want to ask a question? Or that I'm kind of treating this as a roundtable as well. Anybody out there, feel free to come to the podium because it looks like we're about to wrap up. Yes, come on up, Bobby Potter.
So, Mr. Chairman, members of the committee, I'm Bobby Potter, representing this morning the Advisory Council of the State Board of Workers' Compensation. We've had a number of conversations about this. I too would thank you for your letter and the intention of closing the loophole. You all have heard a fair amount about maybe some of those loopholes, providing clarity in the law and to be consistent with the State Board's opinion. I've got a couple of observations beyond what I've heard, and I think there's been some really, really excellent comments. They sort of cut to the chase of the issue. So I won't rehash that. I would say this, that the policy of the board, I think, has been throughout, and the policy of the legislature has been throughout, to find coverage or provide coverage wherever you can for the potentially injured worker and then the injured worker. Over the years in case law, the term liberal construction of the act has been utilized liberally and freely. Sometimes that's gotten reined in, but it certainly is utilized to bring employers and employees within the act. That's way before the creation of leased employees or PEOs or staffing agencies, and it's been after that as well. So it is an important policy to bring people within the scope of the act, which, as a number of speakers have mentioned, provides benefits on the one hand and provides immunity on the other, and one goes with the other. It's unbalanced if one does not go with the other. I would say this, at least as I understand it and as I have heard it, PEOs are not insurers. I think that's fair to say. They purchase insurance, I think, in the open market. So insurers, whether it's of PEOs or general contractors or subcontractors, need to have the ability to appropriately charge for the risks that they've assumed. And as Mike Iverson has indicated, sometimes that risk changes from the time of the insurance contract. Hence, there are audits, and that's a routine part of the workers' compensation world. And in the solution to this problem, I think it likely needs to be part of that issue. As it stands right now, I think it is case law that governs this dilemma. And you all have referenced some of the what's called the Nicholson case, or I guess Mr. Robleau would say it's the Robleau case. And that is decided a certain way. You sort of tried to get into some of the background of that as to why the board did what they did. But that's the case law right now. And right now, that's what we live with. That's what PEOs live with. That's what generals and subs and insurers live with. If we can bring some clarity to that, then I think that would be a good thing. The one other, as I listened today, and I've given this example before, Mr. Chairman, to you and others, the PEOs have indicated that, I think it's Mr. Devlin, that they can't cover what they don't know. And presumably they're listing employees by name when they sign up. The concern, one of the concerns I have had in this world, and it may not have been exactly this case, and it really wouldn't be dealing with intentional fraud, but it's what I'd say the Monday, Wednesday, Friday circumstance is. The indication from the PEOs is they cover what is reported to them, whether that's payroll or however that's going to work. But if an employee comes to work on Monday as an employee of the actual employer that has the relationship with the PEO, and that is reported on a routine Friday payroll or whatever that is, but that employee is injured on Tuesday or Wednesday. In that circumstance, to the PEO, he or she does not exist. But it's a worker who does exist and has been injured. If that's part of the problem, then we need to make that part of the solution, what I'd call the Monday, Wednesday, Friday issue. And we have talked about that on behalf of the advisory council. If we can assist in solving this dilemma, we'll endeavor to do that. If you wish for the ad hoc committee to attempt to do that, then I'm listed as part of that, and I'll try to participate in that as well. Thank you, sir.
Okay, thank you. Dewey McLean had a question online.
Thank you, Mr. Chairman, and thanks everyone for coming. You know, I just, as I listen to everybody, the PEOs, the insurance, the lawyers, my only concern is that, you know, I want to know who is responsible. I mean, when I say who's responsible for the day-to-day activity of the workers, I mean, I hear the fraud, I hear scam, I hear, you know, words that really don't sound good. But the only thing I do know is that the worker needs to be taken care of. So, Mr. Chairman, you had 3 goals and one was closing the loophole. But what I have not heard is someone saying, how are we going to close this loophole? I mean, is the PEOs going to say how they want to close their loophole, or will they do a better job, or the subcontractors? Because I'm thinking from what you said earlier that the subcontractors and the PEOs have some skin in this game. The only one that does not have any skin in this game is the worker. The worker is the one that's out there doing what he has to do and that he's instructed to do, and he's injured. So I would just like to hear from the PEOs or either the subcontractors on what they think is a way to close this loophole.
Okay, well, you want to come up? I mean, I think that's the problem. That's what we're trying to resolve, and that's why we're going to lock them in a room until they come up with answering those three goals.
Right.
Go ahead.
Well, I mean, again, we cover the employee when they're reported. The normal process to bring an employee on is to know their name, to know some general information. As soon as they report that to a professional employer, they're covered. Not when they pay, because they may not pay for 2 weeks. So if they come on today, they're going to be paid biweekly. They're held back a week. It may not be for 3 weeks, but yet they're covered as soon as we add their employee ID, their employee data. Even if we don't have all of it, we need just a general information. They can add their address, they can add other things later, but we need enough information so that on 2 weeks from now, we're going to be able to run a check. So they are covered immediately as soon as they are reported. We have a 24, our professional employer has a 24-hour report line that we've got an online portal. They can email the reps, I mean, there's all kinds of ways to do it. And the professional employer is going to be the one that is responsible, the one that is going to cover those employees. The easiest way to cover the gap, and I'm sure, the majority of the agents are going to agree, it's just not always available to everybody, is to have a minimum premium policy for these kinds of risks that are going to cover these uninsured, that are going to cover these subs, that are going to cover these unknowns, that at the audit time, they are going to pick all that up because a professional employer is going to charge as we go. It's, you know, as they pay the employees, we're going to collect the premium for those last 2 weeks, not for the next year. We're not going to predict it's going to be $1 million in gross pay. We're going to predict it, but the reality is going to be charged on whatever they actually run. So if they run 700,000, they're going to be charged on that. So, you know, there are things to put in place that, you know, allow for this, but, you know, none of the carriers I know of, if they knew a client was picking and choosing employees, they would not only terminate the client, but they would terminate the professional employer.
Okay.
Thank you, Mr. Chairman.
Thank you, Mr. Chairman, and thank you, Representative Dewey, for that question. I think what we need to do is focus on the best way to take care of this problem, and that is you're not trying to stop the fraud. You're never going to do that because people who want to commit fraud will commit fraud no matter what. What you need to do is shut down the vehicle by which they can commit that fraud. And what we have here is this gap in coverage that has been utilized to shut down. It would be a solution to require folks to have those minimum coverage policies. But the one that wants to commit fraud is going to do it because he's not going to get it. He's going to get a false certificate or something. So what you need to do is take away the ability to do that. And so that's why the best solution, I think, is to follow what we already are familiar with. And that is the pattern set under 3498, which is the statutory employer statute, the principal agent, contractor, subcontractor that we're so familiar with, where the contractor sort of polices its own business because he knows that he's going to be responsible if an employee gets hurt and the sub, you know, whoever's below him doesn't have the coverage. So whatever fraud may go in here, you know, you shut it down because you know that up here, you know, eventually you're going to find that coverage, and you give that contractor the tools to go after the person that committed the fraud. And again, going back to what I said is you got to try to put the cost of the injury where it belongs. And so in this situation, it would be very easy to come up with some mirror legislation to 3498, where you basically say that a PEO is going to be responsible for all employees of that client company. Now, you can build in the fact that if they want to sort of divvy up the workforce so that some go into the PEO services contracts, they can do that. But that PEO is going to be ultimately liable if there is no coverage available for the direct employer, those employees that were not under the PEO contract. And so, so what you're doing is, again, you shut in that ability, that you're taking away the tool to commit that, to commit, well, not to commit fraud, because people are going to commit fraud no matter what, but you're taking away the ability to sort of, that leaves this gap, that leaves this employee uninsured. And again, you know, you can do it much like the statute we have now says, that the claim is filed against the direct employer first, you know. And if it turns out that there's no coverage or there's some problem with the coverage, then the claim goes up to the PEO, you know, as a secondary. In other words, we don't want to start suing PEOs every time that we see them in a situation where they're doing business with a company and an employee gets hurt. But you can do it that you go up against that company first. And assuming that there isn't any, then you can move up the ladder, which is essentially what the state board did in that Nicholson opinion, following the statutory law framework that we have under the law. So to me, that would be the easiest solution. We don't need to regulate how PEOs are doing business or what they're supposed to be doing, because now they're going to have a self-interest in ensuring that their clients, you know, meet certain requirements. And one of them being, show me your coverage, make sure that we have coverage, because I don't want to end up being responsible for that. Now, there's going to be situations where that may happen, but what we're trying to do is just close the ability. We want to close that door so nobody can go through it, you know, whether they have good intentions or bad intentions. Let's not get bogged down on who wants to commit fraud. I mean, you're always going to find somebody out there that wants to play fast and loose with the rules and take advantage of loopholes. So my suggestion is focus on taking away that tool, and the best way to close it is to say PO steps in the line of liability for workers' comp, just like contractors and subcontractors. We put them on the line, and in exchange for that, we're going to give them, you know, the tort immunity that they so much want, because that's going to be very helpful for PEOs, because otherwise you might end up in a situation, and Mr. Thaction explained, that you can have a coworker, one that is not under the PEO service contract, injured by somebody who is on the PEO service contract, and now this employee would have no recourse against anybody. Because if the contractor has no coverage, no money, that doesn't do him any good. And he can't sue the PEO on the vicarious liability for the injury that its employee caused. And so you got the worst of all worlds, because then this poor fellow here ends up with no remedy whatsoever under the law. So, you know, what I'm asking is, you know, is just focus on closing, you know, take away the tool, you know. Sometimes loopholes are good. I mean, I know there's a lot of tax lawyers out there make a lot of money finding loopholes, you know, to avoid that. And it's legal, it's not unethical, right? But some loopholes are not good. And this one is not good. So we got to shut it down. And the best way, and the only way I can think of that would minimize the impact, quite frankly, on PEOs would be to put them on that line of liability of workers' comp, on the chain, as we call it. And of course, they're going to get the benefit of the exclusive remedy. And there are ways that they can do to minimize that, much like the contractors have learned to do, insurance companies that work with contractors have learned to do. I mean, we don't have to reinvent the wheel. It is right there under 3498. All we got to do is copy that and mirror that in legislation. Thank you so much.
Thank you.
So Dewey, there's two different answers to your question. And I knew that we wouldn't solve this today, but we do have a very clear directive. I think Tom Kirby was the final. Tom, you there?
Yes, sir. You can hear me, Mr. Chairman?
Yes, yes.
All right. Yeah, been a good day so far. Enjoyed hearing from every side. And with your permission, I'd actually like to put this in form of a motion for the committee to act on. We have an advisory council that has a strong track history of making very good recommendations. So as a form of a motion, I'd like to move that we ask or instruct the advisory council to come back with a recommendation on 390, what's the number again? 397. Before the session begins, and have them working with the ad hoc committee jointly to address these things. And I think as we charge them with coming up with the recommendation, I want to follow up. I want to include something that Representative McLean added, and keeping it simple. A compensable injury is arising out of and in the course of employment in Georgia. Well, arising out of, I think that is the responsibility question that we really want that advisory council to answer with this ad hoc committee. If this is an injury or illness, it's arising out of employment, it's who is responsible for the safety, the regulations, and directing that day-to-day activity of that employee. And so in a form of motion, I'd like to give that charge to our advisory council with working with the ad hoc committee, if that's okay with the chair.
I would take that as a motion, especially since you said alongside the ad hoc committee, so that both groups are working concurrently on that. So yes, with that, is there a second?
I can second that, Mr. Chairman.
All right. All in favor, say aye.
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 Any opposed?
Aye.
Okay. Motion carries. We're going to be adjourned, and so the ad hoc committee has their, as well as the advisory council has the same action given to them, keeping the three goals that I've laid out. And we probably will not meet again before, not only special session, but we'll probably meet as soon as session starts, probably the very first week. But hopefully between those two groups, we can get something that is consistent with each other. Really appreciate y'all coming today. We're adjourned.